Hello and welcome to another emergency episode relating to this term for the Supreme Court. They just keep coming. This one actually came before the last one we talked about, but I wanted to really focus on this case because it's more important than the presidential immunity case, if you can believe it. If you're like, wait, Leeja, all people are talking about is the presidential immunity case. I know. And that's why we have to talk about this case, which overruled a 40-year precedent and will have ramifications for the entirety of our government. Okay? That's bad. So let's talk about it. Media, not talking about it enough, okay? But we noticed the Supreme Court was like, hey, look over there with the presidential immunity case. Well, slyly slipping this one in right before, but we got to talk about it because it's a big deal. The case is 𝗬𝗓𝗪𝗏 Enterprises v. Raimundo, and it was decided June 28th, just before the presidential immunity case, like I said. The case is hugely important, more so than the presidential immunity case, because it deals with every single regulation made by every single regulatory agency in the federal government. In 𝗬𝗓, the Supreme Court fully overruled a long-standing precedent called Chevron deference. They just said, nah, no longer the case. We were wrong. But what is Chevron deference? Before we get into that, we have to do a little bit of background first. Let's talk about the administrative state. That's what the right calls all the agencies that create all the regulations that handle pretty much every aspect of our day-to-day lives, from federal highway regulations to regulating Boeing and all the doors that keep flying off to clean air or the lack thereof. Everything that keeps mainly big businesses in check a lot of the times are the regulations that are part of the administrative state. So obviously conservatives fucking hate it because it's really inconvenient for billionaires to, have the government breathing down their back to make sure they're not committing like heinous crimes and stuff like that. So inconvenient for sure. The administrative state is part of the executive branch. So Congress passes law which gives administrative agencies and department heads the right to enforce those laws through the creation of regulations, but the actual agencies are answerable to the president. But for a while, there was a lot of ambiguity as to, okay, if Congress passes a law and there's something in the law that's a little bit unclear, who gets to interpret what it means? Is it the courts or is it the agencies tasked with enforcing the law? And in 1984, Chevron v. NRDC came along and it made that decision for us. You'll see it here to the right of your screen. It was a decision made June 25th, 1984. And yes, that's almost exactly 40 years to the day to the most recent ruling that completely overruled this decision. And with all of these administrative law cases, they can get into the nitty-gritty details of like agencies and exact regulations. They can get a little tedious to read. I took an admin law class in law school. My eyes were glazed over for half of it. So I don't blame you for being like, this isn't really a sexy topic. I don't really care. But you should care. And so we're going to just go over the highlights of this case. So the EPA had made a regulation saying that a state could adopt a plant-wide definition of the term stationary source. Under this definition, an existing plant that contains several pollution-emitting devices may install or modify one piece of equipment without meeting the permit conditions if the alteration will not increase the total emissions from the plant. The question presented by these cases is whether EPA's decision to allow states to treat all of the pollution-emitting devices within the same industrial grouping as though they were encased within a single bubble is based on a reasonable construction of the statutory term stationary source. You see how this gets super technical and super boring? We don't need to go into the details here, but I want you to grasp that. This is technical and boring, okay? Probably best left to, experts who have background in this, right? So the EPA basically made the ruling that if there's a plant and they want to modify a single thing in that plant that creates pollution, they don't have to apply for a permit and have the EPA kind of look at if that singular modification fits within their regulations. They can take the plant as a whole and say, like, generally, is this entire bubble of a plant more polluting or less polluting? Is it falling within the regulations? And if it is, then they're fine. They can do the little modification without a permit. This was actually a win for Republicans at the time. This is 1984. We're in peak Reagan time, so they were really against regulations unless it served them well. And in this case, it did, because it meant that they weren't going to be as specific and piecemeal with regulations around these polluting businesses. So at the time that Chevron was decided, it was a pro-Republican decision because the Supreme Court found in favor of the EPA. The Supreme Court found that it was within the EPA's purview as an agency to make this determination because Congress was not explicit on what a stationary source meant. The EPA was the one who should be making that determination, not courts. And they set out a two-part test, which has become known as Chevron deference. When a court reviews an agency's construction of the statute which it administers, it is confronted with two questions. First, step one, always, is the question whether Congress has directly spoken to the precise question at issue. If the intent of Congress is clear, that's the end of the matter. For the court, as well as the agency, must give effect to the unambiguously expressed intent of Congress. So first step, did Congress say exactly what they meant? Great, you go with that. If, however, the court determines Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction on the statute, as would be necessary in the absence of an administrative interpretation. Rather, if the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. Okay, so first, did Congress say anything about this? If they did, great, let's do what Congress wanted. If not, it's not up to the courts to just give a definition. It's up to the courts to defer to the agency who has the expertise, the background, the knowledge, on-the-ground experience to make a determination based on a number of factors and weighing different needs what the correct interpretation of the words are. Basically, it's not a court's place to do this. It's an agency's place. If Congress has explicitly left a gap for the agency to fill, there's an express delegation of authority to the agency to elucidate a specific provision of the statute by regulation. Such legislative regulations are given controlling weight unless they are arbitrary, capricious, or manifestly contrary to the statute. So the court has a role here. First, they have to determine, did Congress speak to this? And then second, they have to determine whether or not the regulation that the agency created was arbitrary, capricious, or manifestly contrary to the statute. So basically, is the regulation reasonable under the statute? Is it a reasonable interpretation of what the statute says? Great. That's the court's role. So the court does have a role to play here. The role just stops short of them actually saying what the law explicitly means because they are not the people with the expertise necessary to make those determinations. That's what you need to know from this case, Chevron from 1984. So we give deference to agencies, yes, but there is still our traditional checks and balances in place. Congress passes the laws that the federal agencies administer, and Congress gives agencies the responsibility to administer those laws. Federal agencies are directly accountable to the U.S. president, the only public official elected nationally to serve the entire country. They are also accountable to Congress, which controls their funding, and through the Senate decides whether to confirm each agency's senior leadership nominees. So we're balancing the three branches. This deference is important, and I'm quoting directly from the NRDC's own website. They're the ones who lost in Chevron, I'll remind you. It protects the essential role of federal agencies in writing the rules and standards required to administer laws passed by Congress to protect, for example, public health, worker safety, the integrity of financial markets, or the quality of our air, food, water, and medicine. It allows federal agencies, which are accountable to elected officials and have developed decades of expertise in the tasks that Congress has assigned to them, to do their duty on the public's behalf without having their reasonable policy choices second-guessed by unelected judges. It provides judges with clear guidelines for resolving legal disputes regarding the administration of laws intended to safeguard the public. Clear guidelines, that's key. And it clarifies the roles of the three branches of federal government so as to promote nationwide consistency in the administration of our laws and minimize the number of conflicting court decisions due to diverse policy inclinations from individual judges, okay? So it's keeping it simple, it's giving judges guardrails, and it's allowing for the administration of laws based on the expertise of the people who were given the task to administer them. But conservatives generally hate the administrative state. Part of Project 2025 is to dismantle it as much as possible. So getting rid of Chevron deference, which puts so much power in the hands of agencies, is at the top of their list, and they've been working on this for decades, okay? And this falls under a theory that is promulgated a lot repetitively in Project 2025, and that is the unitary executive theory. We talked about this in my Project 2025 video. Here's what I said in that video. Unitary executive theory. It's this batshit theory that has only been made up in the last few decades. In fact, we have our good old friend Ronald fucking Reagan to blame once again for its proliferation, because of course. The theory came to prominence during Reagan, but really put down roots during the presidency of George W. Bush. Basically, the theory rejects the idea of three equal branches of government put in place to ensure a rigorous system of checks and balances so no one branch becomes too powerful. Instead, the unitary executive theory says actually, inherent in Article 2 of the Constitution, the president has complete control of the executive branch. So Congress can't create all of these agencies and put power in the hands of agency heads to make decisions. That power is supposed to be concentrated in the hands of the one singular executive. And so I hope what's clear from that is that Chevron deference really got in the way of that theory, because Chevron deference says, hey, judges, you can't question the reasonable interpretation by agencies of the laws Congress writes. But without that pesky Chevron deference, now anyone can challenge a rule made by any agency, say for clean air or motor vehicle safety, or antitrust regulations, or any of the host of regulations that conservatives and billionaires, the ones who bankroll our very Supreme Court justices, find so annoying. And a random, unelected judge in court can override the expertise of these agencies and their regulations and say, nah, I don't think that's what Congress meant by that. And those judges are the ones that Trump has put in place with abandon, including in this very Supreme Court. And if you watched my last video about presidential immunity, you'll remember that I said that the case put a ton of power into the hands of the judiciary, who now has the power to say which crimes a president can even be tried for to begin with. And when you combine that with this latest ruling, plus a host of other smaller, more obscure cases that they decided this term that limited agency powers, in the span of a single week, the Supreme Court just granted itself enormous, unprecedented amounts of power. And that's on purpose. But we'll get into that. First, let's take a look at the highlights of the Loper case. Last video, we spent over an hour really digging into the nitty-gritty of the presidential immunity case, and that's because I think a lot of people had very specific questions about the boundaries of presidential power after that decision, and a close reading warranted that. Here, however, like I said, the facts of the case are more obscure, they're less generally interesting, they're boring, they're very tedious, they're probably best left to experts, one would say. So I'm not gonna get into the nitty-gritty. The decision is linked below for your perusing should you so wish. But here's a basic background. So the petitioner, Loper Bright Enterprises et al., are a group of fishing businesses that catch herring in the Atlantic Sea. They're suing Gia Raimondo, the U.S. Secretary of Commerce, not because she personally did something wrong, but that's commonly how you challenge government actions. You sue the person in charge of the body that made the regulations, and in doing so, you're essentially suing the whole department. And these fishermen, these fish boys, if you will, fishermen, gender exclusive, fish boys, anyone can be a fish boy. All genders are included. So I'm going to be calling them fish boys, okay? With an I. The Fish Boys are suing about a law called the Magnuson-Stevens Fishery Conservation Management Act, which has been shortened to MSA. So the MSA is the act passed by Congress. In that act, Congress gave the Department of Commerce the authority to enforce the provisions of the act, which relate to fishery conservation management. And from there, the Department of Commerce created the National Marine Fisheries Service, a government agency that oversees the enforcement of the MSA, the act relating to fishery conservation. Hopefully that makes sense. When I was in admin law, like I said, my eyes just fully glazed over. So Congress says, hey, Department of Commerce, you're in charge of dealing generally with business, and this is a fish business, and we want to make sure that we are conserving our fisheries. So you're in charge. And then the department was like, great, here's the NMFS, the National Marine Fisheries Service. They're going to be the experts who pass the regulations necessary to enforce this act passed by Congress. Bada bing, bada boom, you're seeing the administrative state in action. Then you take it a step further. There's also regional councils to help further specialize the regulations. So there are hyper-specific local councils that are helping form federal regulations. They have the local knowledge and expertise and are actually on the ground, and they're the ones going up the chain creating rules to enforce the law that Congress passed. Okay, we're on the same page. So the National Marine Fisheries Service created some rules. They said, hey, if you're going to be doing fishing in our waters, you got to be reporting what you're doing, and we're going to limit certain activities in order to make sure that we're not overfishing the waters. And in order to make sure that you're following the rules, we're going to require occasional third-party observers to come aboard to check on things. For a while, those third-party observers were paid out of government coffers, but then in 2013, an amendment was proposed that if there isn't sufficient government funding, those observers still are required, and fishermen have to pay for it themselves. The petitioners, a bunch of fish boys, were obviously pissed. How are you going to pass rules like this and then make me pay for it? Truly a libertarian nightmare. But also I can empathize. Like, I get why it would be annoying, especially for smaller fishery. Observers could cost upwards of over $700 per day. So they sued, saying that the MSA, that act passed by Congress all those years ago, does not give the NMFS, the National Marine Fisheries Service, the power to make them pay for these observers. And in this lawsuit, the fish boys were fully stonewalled, basically. The district court didn't even let it go to trial. They just said, hey, listen, we get your arguments, but our hands are tied. Chevron Chevron deference means we have to defer to the NMFS because Congress didn't explicitly say anything about this in their act. And it's reasonable for the NMFS to have determined this provision was necessary. Because of Chevron deference, we defer to them. And the DC Circuit Court affirmed that decision, again, because of Chevron deference. And then separately, another group of fish boys sued over the same rule and lost for the same reasons in the district court, which was then affirmed by the First Circuit. So then both cases appealed up to the Supreme Court, and since they're addressing the same issue, they were combined into one case. Got it? Great. And the court jumped on this case because they have been just running rampant, overturning long-held precedent. So why stop now, you know? So the question before them was whether Chevron should be overruled or clarified. Or clarified being key here. They could have decided to simply clarify Chevron, add some guardrails, create a clearer test, but now they said, no, not today. Today we choose violence. And then they struck it down entirely. But let's look at their reasoning, shall we? Obviously, first, we love to talk about the framers and what they wanted. The framers envisioned that the final interpretation of the laws would be the proper and peculiar province of the courts. Unlike the political branches, the courts would, by design, exercise neither force nor will, but merely judgment, to ensure the steady, upright, and impartial administration of the laws. The framers structured the Constitution to allow judges to exercise that judgment independent of influence from the political branches, which is an interesting quote. Neither force nor will, but merely judgment. Here they're claiming legitimacy by saying, look, the framers said we judges were impartially administering laws. We do not exercise force or will, but merely judgment, okay? We are completely unbiased arbiters of the law, obviously. Don't pay attention to the fact that one of us had January 6th flags flying over multiple of our houses, or the other one is, married to someone who actually actively tried to overthrow the government. No. But we are capable of complete lack of bias. So we are the ones who should be the only ones allowed to say what the law says. They talk a little bit more about what the framers wanted, and then they go on to the New Deal. Obviously, conservatives love starting conversations about the administrative state with the New Deal, because that was a huge expansion of government that they've been mad about ever since. But honestly, I'm going to stop there. We're not even going to go through the majority of the main opinion because it's really technical, and all the arguments against it are in Kagan's dissent, and her dissent is really the only thing that matters because it's actually great. And so honestly, that's what I want to look at for most of this time because she kind of tears him a new asshole, and it's really fun to watch. Clarence Thomas, of course, wrote a concurring opinion agreeing with the majority, but also saying actually we should go a step further. Chevron is completely unconstitutional and totally violates separation of powers because he loves harping on about separation of powers when it suits him. Gorsuch then also wrote a separate concurring opinion about stare decisis, that's deference to precedent, saying actually stare decisis definitely fits and in fact encourages our overturning of Chevron here. It's fine, okay? Which doesn't make any sense, but sure, Gorsuch. I'm excited to have partnered with Planet Wild on this video. The administrative state includes the EPA, whose authority has been gutted by this case. But there are other things we can do to help push for the things we care about. With Planet Wild, you can take action now to protect nature and endangered animals. More on them later. But I want to jump ahead to Kagan. Let's talk about the dissent, because you're going to get a lot of what the main argument was from her dissent tearing it apart. Justice Kagan wrote it with Justice Sotomayor joining, Justice Jackson also joining, dissenting. Here's where Kagan starts. This court has long understood Chevron deference to reflect what Congress would want, and so to be rooted in a presumption of legislative intent. Congress knows that it does not, in fact, cannot write perfectly complete regulatory statutes. It knows that those statutes will inevitably contain ambiguities that some other actors will have to resolve, and gaps that some other actor will have to fill. And it would usually prefer that actor to be the responsible agency, not a court. Some interpretive issues arising in the regulatory context involve scientific or technical subject matter. Agencies have expertise in those areas. Courts do not. Some demand a detailed understanding of complex and interdependent regulatory programs. Agencies know those programs inside out. Again, courts do not. And some present policy choices, including trade-offs between competing goods. Agencies report to a president, who in turn answers to the public for his policy calls. Courts have no such accountability and no proper basis for making policy. And of course, Congress has conferred on that expert, experienced, and politically accountable agency the authority to administer, to make rules about, and otherwise implement the statute giving rise to the ambiguity or gap. Put all that together, and deference to the agency is the almost obvious choice based on an implicit congressional delegation of interpretive authority. We defer, the court has explained, because of a presumption that Congress would have desired the agency rather than the courts to exercise whatever degree of discretion the statute allows. Basically, it's just obvious common sense that Congress would want the agency to which it has delegated authority over the law to then be the one to interpret the law. But even beyond common sense, she goes on to point to more reasons why Chevron should stand. In one fell swoop, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. As if it did not have enough on its plate, the majority turns itself into the country's administrative czar. It defends that move as one suddenly required by the nearly 80-year-old Administrative Procedure Act. But the act makes no such demand. Today's decision is not one Congress directed. It is entirely the majority's choice. The Administrative Procedure Act, like she said, was passed 80 years ago, and it helps to define what agencies can and cannot do. And the majority argued that before Chevron, under the APA, everyone understood that it was actually judges who should be the ones making this decision. And then Chevron came and totally fucked it up, as if there hasn't also been 40 years of precedent since Chevron re-examining it and continuing to agree with its precepts. We just all of a sudden today have realized, oh no, Chevron's been wrong this whole time. Okay, and then this is a great quote. The majority cannot destroy one doctrine of judicial humility without making a laughingstock of a second. If opinions had titles, a good candidate for today's would be hubris squared. Sick burn, Kagan. Stare decisis is, among other things, a way to remind judges that wisdom often lies in what prior judges have done. It is a break on the urge to convert every new judge's opinion into a new legal rule or regime. Basically, stare decisis is looking to the past legal decisions and relying on those decisions as established law to build upon, as opposed to just overruling it willy-nilly. And she says the court's justification comes down in the end to this. Courts must have more say over regulation, over the provision of healthcare, the protection of the environment, the safety of consumer products, the efficacy of transportation systems, and so on. A long-standing precedent at the crux of administrative governments thus falls victim to a bald assertion of judicial authority. The majority disdains restraint and grasps for power. True. And then she lays out some concrete examples of the questions that are posed in these administrative cases, where now, because they're overruling Chevron, judges are the ones that would be deciding these questions as opposed to giving deference to the agency's interpretation. Some of these questions include, when does an alpha amino acid polymer qualify as such a protein? Must it have a specific defined sequence of amino acids? Or what makes one population segment of squirrels distinct from another? Must the service treat the Washington state population of western gray squirrels as distinct because it is geographically separated from other western gray squirrels? Or can the service take into account that the genetic makeup of the Washington population does not differ markedly from the rest? Or how should the Department of Health and Human Services measure a geographic area, by city, by county, by metropolitan area? Or in the Grand Canyon, how much noise is consistent with the natural quiet, and how much of the park for how many hours a day must be that quiet for the substantial restoration requirement to be met? Or in the Chevron case itself, does the term stationary source refer to each pollution-emitting piece of equipment within a plant, or does it refer to the entire plant? These are questions that before agencies got to decide, agencies filled with experts who have spent their lives studying these issues. Now, the court is saying, nah, that's up for us to decide. We're the ones, we're the experts. And as Kagan says, an agency's construction of a statutory term benefits from its unique exposure to all the related ways the term comes into play. There are many examples where courts have made decisions without realizing the full breadth of the consequences of that decision. Here, that would be a huge issue because the court doesn't see the day-to-day workings of regulations in the field. They don't know how they play out, so they have no idea what the consequences of their decisions are going to be. They can have stakeholders come in and submit amicus briefs and try to brief them on what their decision could mean long term, but they simply don't have the capacity to have the expertise and the experience that people on the ground who are writing these regulations have. But this Supreme Court says, fuck it, we can do it. And because of this, because they don't understand the consequences and there are so many competing interests at play, Kagan says the task is less one of construing a text than of balancing competing goals and values. Consider the statutory directive to achieve substantial restoration of the Grand Canyon's natural quiet. Someone is going to have to decide exactly what that statute means for air traffic over the canyon. How many flights, in what places, and at what times are consistent with restoring enough natural quiet on the ground? That is a policy trade-off of a kind familiar to agencies, but peculiarly unsuited to judges. Again, the majority says, no, this is just about determining what the law says, and that's our job. But when you look at the reality of the questions being posed, yes, technically it comes down to determining what the law means, what the words in the law means, but making that determination requires balancing different policy arguments based on deep knowledge of the issue. It's not just a means of interpreting law and legal interpretation that you learn in law school. That should be left to agencies, and in fact, Congress would want that to be left to agencies. This is a choice a judge should not be making, but one an agency properly can. Agencies are subject to the supervision of the president, who in turn answers to the public. So when faced with the statutory ambiguity, an agency to which Congress has delegated policymaking responsibilities may rely on an accountable actor's views of wise policies to inform its judgments. And Thomas, in his concurrence, was so concerned with separation of powers, but none of them seemed concerned with the will of the people and who is ultimately answerable to them. Agencies are overseen by the president, who is elected by the people. Judges are not. But Thomas doesn't seem to give a fuck about that. And then she goes on, none of this is to say that deference to agencies is always appropriate. The court over time has fine-tuned the Chevron regime to deny deference in classes of cases in which Congress has no reason to prefer an agency to a court. The majority treats those refinements as a flaw in the scheme, but they are anything but. Because Chevron didn't end with the Chevron decision 40 years ago, and that's the only thing they've been relying on. It's been refined over the years, so there are many exceptions to that deference. It's not blind and blanket deference, and there are protections in place so that where appropriate, judges can still make interpretations. It's a fine-tuning that's happened over decades that the majority opinion just completely overrules with brute force and puts in place a blanket ruling that agencies can't interpret what the law says. And now that ruling is going to need to be refined for decades while we figure out what the fuck that means. And under Chevron, Kagan points out the court still has a role to play. It polices the agency to ensure that it acts within the zone of reasonable options. But the court does not insert itself into an agency's expertise-driven, policy-laden functions. That is the arrangement best suited to keep every actor in its proper lane, and it is the one best suited to ensure that Congress's statutes work in the way Congress intended. Another sick burn from Kagan. The majority makes 2 points in reply, neither convincing. First, it insists that agencies have no special competence in filling gaps or resolving ambiguities in regulatory statutes. Rather, courts do. Score 1 for self-confidence, maybe not so high for self-reflection or knowledge. Of course, courts often construe legal texts hopefully well, and Chevron's first step takes full advantage of that talent. The deference comes in only if the court cannot do so. If the court must admit that standard legal tools will not avail to fill a statutory silence or give content to an ambiguous term. Basically, if Congress didn't say anything, if they can't figure out exactly what Congress meant, then they get to defer to the agency. But before that, the judge still has a role to play. Another blow, the idea that courts have special competence in deciding such questions, whereas agencies have none, is, if I may say, malarkey. Scandalous. Answering those questions right does not mainly demand the interpretive skills courts possess. She goes on to talk about Congress and what Congress actually wants out of this. Chevron is built on a presumption. The decision does not maintain that Congress in every case wants the agency rather than a court to fill in the gaps. The decision maintains that when Congress does not expressly pick one or the other, we need a default rule. And the best default rule, agency or court, is the one we think Congress would generally want. As to why Congress would generally want the agency, the answer lies in everything said above about Congress's delegation of regulatory power to the agency and the agency's special competencies. And as with any default rule, if Congress decides otherwise, all it need do is say. It just needs to add a line to the law that they pass saying all deference should go to judges in interpreting this law. That's all they'd have to say, because they know that Chevron exists. It's been around for 40 years. They know when they write a law that it's going to be left to the agencies to interpret it. And if they don't want that, they can just add a little line in the law to make sure that it's the judges that are doing the interpreting. And they usually don't do that. In that respect, the proof really is in the pudding. Congress basically never says otherwise, suggesting that Chevron chose the presumption aligning with legislative intent. For 4 decades, Congress has operated knowing that under Chevron, ambiguities in the law would be deciphered by the agency, and they haven't done anything to change Chevron. Congress could. They could even pass a law codifying Chevron or completely overruling Chevron. They could have been doing that for 40 years. They never have, and they don't even write into their laws to overcome a Chevron deference. So clearly, if they wanted to, they would. If he wanted to, he would. That's the takeaway. And they didn't. And the Supreme Court says, no, they're wrong. Everything's wrong. We're right. You're wrong. You're dumb. Shut up. Now let's get into stare decisis. Abandoning Chevron subverts every known principle of stare decisis. Of course, respecting precedent is not an inexorable command, but overthrowing it requires far more than the majority has offered up here. Chevron is entitled to stare decisis' strongest form of protection. The majority thus needs an exceptionally strong reason to overturn the decision, above and beyond thinking it wrong, and it has nothing approaching such a justification, proposing only a bewildering theory about Chevron's unworkability. So basically, the majority says, look, Chevron's, it's too confusing. It's not workable. We can't function like this. This is crazy. It's way too complicated. We gotta do away with it. And that's kind of their entire reasoning for doing away with it. But when there's 40 years of precedent and it has continually reinforced the strength of the stare decisis that comes in here means that they need to have a really fucking good reason to overrule it. That's just how we function as judges. We can't just be overruling things willy-nilly. That goes against all judicial ethics, rules, standards of procedure. Generally speaking, if a judge can maintain the status quo, they should. But here Justice Kagan says, the decision today will cause a massive shock to the legal system, casting doubt on many settled constructions of statutes and threatening the interests of many parties who have relied on them for years. So this level of upset that they're creating by overruling Chevron needs to be backed by a really fucking good reason, and they don't give that. Because stare decisis enables people to order their lives in reliance on judicial decisions, and it contributes to the actual and perceived integrity of the judicial process by ensuring that those decisions are founded in the law and not in the personal preferences of judges. But this Supreme Court does not give a fuck about any of that, and we know that. We've seen that over and over again. And then she says, perhaps above all else, stare decisis is a doctrine of judicial modesty, in that it shares something important with Chevron. Both tell judges that they do not know everything and would do well to attend to the views of others. So today, the majority rejects what judicial humility counsels not just once, but twice over. And as to the complexity of Chevron deference, she says lower courts have applied the Chevron framework on thousands upon thousands of occasions. It's as embedded gets in the law. Yet she says that there have been cases since 2016 specifically where Chevron deference has been questioned by the members of this very court. And she says this court has avoided deferring under Chevron since 2016 because it has been preparing to overrule Chevron since around that time. That kind of self-help on the way to reversing precedent has become almost routine at this court. Stop applying a decision where one should, throw some gratuitous criticisms into a couple opinions, issue a few separate writings, questioning the decision's premises, give the whole process a few years, and voila, you have a justification for overruling the decision. Basically, they're relying on their own previous opinions, questioning this case in order to overrule it. That's not enough. Or it shouldn't be. And I think it really lays bare this court's own scheme in a very explicit way that I think we're all seeing, but seeing it written down by a Supreme Court justice herself is like, it's a little twist of the knife, but it's also confirmation. Like, no, you're not crazy. This is what's happening. And at one point in the majority's decision, they say this Chevron deference is unworkable because it is just crazy. It's hard to follow. It's just a difficult interpretation. It's too hard. It's a dizzying breakdance, they said. And in response, Kagan said, for the most part, the exceptions that so upset the majority require merely a rote, check-the-box inquiry. If that is the majority's idea of a dizzying breakdance, the majority needs to get out more. Kagan's clerks definitely had a fun time writing this because Supreme Court justices don't write their own opinions. They have clerks who do it for them, and then they just read it and check off on it. But frankly, honestly, the tongue-in-cheek nature of this dissent and a lot of the dissents, and even the majority opinions sometimes, it's a bit unsettling because it's just an example of the deterioration of the legitimacy of this court. That we're talking about breakdancing and that some of the justices need to get out more, you know? I don't want my Supreme Court justices writing the way that, like, lawyers on YouTube speak. Leave that to me, okay? I want a little, at least, semblance of formality from my Supreme Court justices. As much as I love a sick burn, it's a little unsettling. Congress and agencies alike have relied on Chevron, have assumed its existence in much of their work for the last 40 years. Statutes passed during that time reflect the expectation that Chevron would allocate interpretive authority between agencies and courts. Rules issued during the period likewise presuppose that statutory ambiguities were the agencies to reasonably resolve. Those agencies' interpretations may have benefited regulated entities, or they may have protected members of the broader public. Either way, private parties have ordered their affairs, their business and financial decisions, their healthcare decisions, their educational decisions around agency actions that are suddenly now subject to challenge. So this kind of lays out the chaos that overturning Chevron will do. And it's also another point for not overturning it, exercising judicial restraint and humility, which the court does not do in this. And she says, in every sphere of current or future federal regulation, expect courts from now on to play a commanding role. It is not a role Congress has given to them in the APA or any other statute. It is a role this court has now claimed for itself as well as for other judges. Once again, with respect, I dissent. Okay, so that's the decision. What are the long-ranging consequences of this? Kagan got into a little bit, but judges will be determining things like aviation safety, medical regulations, food safety, environmental regulations, everything, despite having no expertise in these areas. For example, in another case, the court decided this term, Ohio v. EPA, Justice Gorsuch's opinion referred to nitrogen oxide, the gas that causes pollution, as nitrous oxide, which is laughing gas. And it wasn't a single slip up. He referred to it as nitrous oxide 5 times in that opinion. So we're putting regulatory decisions into the hands of a bunch of unelected people who mistake smog for laughing gas. Do I personally know the difference between nitrogen oxide and nitrous oxide? Of course not. Absolutely not. This is why I'm not the one promulgating regulations about it. But judges apparently can, and in fact, frankly, should, I guess. And with a judiciary packed to the gills with anti-regulatory judges put in place by Trump, this means that the Supreme Court just handed their billionaire benefactors a huge win. And to say that this makes their billionaire pals happy isn't just a conspiracy theory, okay? The Koch brothers funded this entire case. This is funded by the Koch brothers, the Koch enterprises. And I'm certain that the Fish Boys were probably annoyed with the extra expenses, but this was a case of legal activism, not on the Fish Boys' part, but on the part of very, very rich people who stood to gain a lot by pushing for an end to the administrative state with its pesky regulations. So they were just waiting for the right case to come along. This wasn't a case of lawyers advocating fiercely for the rights of some lowly fish boys, okay? It was a case of billionaires using working class people to further their personal interests, as always. The lawyers representing the fisheries are working pro bono for their clients and belong to a public interest firm called Cause of Action. Cause of Action does not disclose its donors, of course, but according to the New York Times, court records show that the lawyers on the case also work for Americans for Prosperity, a group funded by Charles Koch. The Cause of Action board of directors also includes a top lawyer at the firm that has represented Koch Industries in a bunch of cases and currently is representing Koch Industries in a lawsuit against them by the Minnesota Attorney General. And the board of directors also includes executives at groups funded by Charles Koch or Koch Industries. Of course, there are enough layers of separation between Koch and this case, thin, flaky, barely there layers, but enough layers in this legal landscape to create plausible deniability that this is just about those poor lowly fishermen. That's what we're in it for. It's just about them. Don't look behind the curtain. But don't be fooled and see this for what it is. It's judicial activism making a power grab for the billionaires who put those justices in place and fund their lavish vacations and lifestyles. And overturning Chevron along with Roe v. Wade has been on their bucket list for a very long time. Congress, for its part, could pass a law amending the APA to codify Chevron deference so that it is very clear that Congress means ambiguities to be interpreted by agencies and not by judges. As far as I can tell, nothing's been introduced at this point to amend the APA. Maybe it's in the works, but a cursory Google search did not find anything. But Tennessee Representative Mark Green did introduce a bill that would force all agencies to sunset any regulation they've passed that was upheld in court under the Chevron doctrine, which is insane and would require review of all Chevron cases and would completely upend regulations in tons of agencies. It hopefully won't get far. It's just a bill that he's introduced, but I am eager to see anyone in Congress, make a move to amend the APA and codify Chevron, and I'm not seeing that so far. So call your representatives and tell them that you want Chevron codified. Short of that, there is very little standing in the way of the massive tidal wave of lawsuits that are certainly already waiting in the wings to gut regulations of every agency in the federal government. There are so many conservative lawyers that have been trying for decades to get rid of agency regulations, and they've just been given a free ticket to ride. And this is why voting in November matters. I don't give a flying fuck if they have to weekend at Bernie's Biden across that stage to the finish line. When you vote for Biden, you're not just voting for one guy, you're voting for a group of people, the people behind the scenes that are actually the ones pulling the strings. Are they always working in our best interests? Absolutely not. But at the very least, they're not trying to fundamentally upend the functioning of our government and will appoint judges who hopefully generally understand the limits of their own power. But only time will tell. Please fucking vote. Holy shit. Sometimes we can't rely on the government to come save us, and in those moments, we need to turn to other ways we can make a direct impact. That's where my friends at Planet Wild come in. Planet Wild is a forward-thinking nature protection organization and a certified B Corporation. They have a fascinating approach, connecting people who want to financially contribute to environmental protection with monthly projects that know how to do it efficiently. The projects on the ground carry out the work in our name as part of the Planet Wild online community, and then document all the work and investment done on short, informative videos videos here on YouTube so you can make a big difference even if you're not on the ground. And as a member, we get complete 100% impact transparency. So we know where our money is going and can see the impact that it's making. In their latest video, they're saving baby sharks in Malta and giving you a behind the scenes look. Membership starts at $6 per month. So for the price of a cup of coffee, you can help create change and protect our planet. And you can cancel anytime. Since I think they're doing such a great job, I encourage you to subscribe now. And the first month will be covered with my code 𝗬𝗎7, so you can see for yourself the impact that we could have together. You can click the link in the description or scan this QR code. Don't forget to check out Planet Wild's video to see their newest project and the great impact that we're already having. Thanks so much for watching. Have a good day. Bye-bye.